It's great to be with you today. And so as you probably already know, we're going to be covering commercial lease negotiation tactics for small business owners. This is a partnership between the City of Oakland and the Lawyers Committee for Civil Rights of the SF Bay area. And because of this partnership, the presentation is focused on Oakland. But if we have folks in the room who are from San Francisco or San Jose, they can indicate in the chat box that that's where you're located, and then we'll also be sure to cover San Jose and SF. And there will be points in the presentation where we take a break for questions, and again, you can just pose those in the Q&A box, as Anna said. Before we get started, just a disclaimer that this presentation is not meant to be legal advice. We're just providing you with information based on our experience and advising other tenants and researching the relative moratoria. The presentation is updated as of the end of the month, end of October. And so if anything has changed in the intervening week or so, just keep that in mind to double check anything in case there are additional protections or new funding sources, which we'll talk about, have been opened up. And we'll include a link at the end if you need more information or if you'd like to speak with an attorney. The Lawyers Committee is staffing commercial lease consultations with volunteer attorneys where you can sign up. You'll get 1 hour of complimentary time with an attorney to talk about your options, talk about negotiating with your landlord, answer questions about your lease. So we'll give you a link to sign up for one of those after the presentation. As far as what we'll cover today, we're going to start by just the first steps you need to take to negotiate with your landlord, or before you start negotiating with your landlord. We'll cover the relevant protections in Oakland, and then again, San Francisco and San Jose. If we have any folks from those two cities here, please just comment in the chat box. And we'll then cover tips for negotiating with your landlord. So before you, or when you start this process, you're going to want to first review your lease. That includes all exhibits or appendices. You want to just do a full read through of the document so that you have a basic understanding of what the requirements are. Even as a lawyer, like many of you, I sometimes am not as thorough when I'm asked to agree to a user agreement or even when I've signed a lease. And so some of you may not be familiar with those terms. So just make sure you have read through it once. Again, there's always the option to sign up for a consult to have a lawyer review the lease as well. If you have sublet the space from someone, someone was in the space and then subleased it to you versus you leasing it directly from the landlord, you'll want to review the master lease if you have a copy, and that's the original lease between the landlord and the person you subleased from, as well as your sublease. And if you have leased the space for multiple terms, if there was any renewal document, sometimes with leases there are options to extend. Sometimes that's just a matter of sending a written communication to the landlord and there's nothing else. But if the lease has changed over time or been amended, just make sure that you gather all of those documents and review them ahead of time. And we've had some questions from some commercial tenants about what they should do if they don't have a lease. And in that case, you could have some more options in terms of walking away. Often an oral lease or agreement is on a month-to-month basis. And so you would probably want to sign up for a lease consultation to talk with a lawyer through what the agreement was, the rent, those kinds of things, just to get a full picture. But keep in mind that you may have more options if you don't actually have a written lease. In terms of things to look for when you're reviewing the lease, keep an eye out for common area and other shared expenses. These are often included under a section that's called additional rent. As we'll see in some of the different locations, in terms of rent that is not required to be paid if you meet the moratorium criteria, this additional rent or these additional rent categories can be included in what you are exempted from paying right There may also be provisions discussing abatement of rent and other rights that you have, and this is especially true if you have not been able to access the building or the space that you're renting at any point since the COVID shutdowns began, and also if the landlord has cut off any services that he or she is required to provide under your lease. All could lead to reductions in your rent down the road. I've been helping tenants with these consultations since March or April, I believe, and I have not seen a force majeure clause in any of the leases I reviewed, but still keep an eye out for it as you're reviewing your lease. What force majeure means is essentially act of God, and so these clauses can potentially be interpreted to include something like a pandemic that prevented you from meeting the obligations of your lease, and therefore could be grounds for you to have your rent reduced or potentially eliminated during the relevant time period that you were shut down. There also may be provisions guaranteeing your right to access or use the property. And again, similar to the earlier point, if you were interrupted or prevented from using the property at any point, could be helpful. There are often condemnation or casualty provisions in a lease, and these are usually due to the history of San Francisco and the area for earthquakes. And usually there's, if 50% of the building or premises is damaged, 50% or less, then the landlord has a certain amount of time to repair them before you can walk away from the lease. Other portions will say if it's more than 50% damage, then you have a right to walk away. Usually these do not cover something like a pandemic, but if there's any mention of a loss of use of the space or a loss of access, that could be helpful. If you are renting space in a building that has multiple commercial spaces, where you're renting a stall in a larger area, like an open air market or indoor outdoor market or a food court or shopping mall, that your lease may require that the landlord maintain a certain level of occupancy or that it be open for certain hours. And if the landlord didn't meet these requirements because of the shutdown, it could be a possibility that you could terminate the lease if termination is triggered if the landlord fails to meet the occupancy threshold. And there could be other rights for you to assert under that type of provision. We've mentioned quiet enjoyment, security deposits. Almost all tenants are going to submit a security deposit. It could be anywhere from a month's rent to a much larger amount. And so just look for those. It's usually a distinct provision, and just see what the requirements are. Some leases will say if the landlord does not receive payment of rent, the landlord can apply the security deposit toward the rent. And some leases also require that the tenant repay the deposit within a certain amount of time of that happening. So just make a note of that. If there are other options for you in terms of grounds you can assert outside the four corners of the lease, you would want to talk to an attorney about those. So please sign up for a lease consultation to talk about those possibilities. And that would include commercial frustration of purpose as well. The first step, once you've gathered your documents and you reviewed them relative to your lease, you want to notify your landlord. So this is important to keep an open dialogue, keep talking if you can. You want to at least meet the minimum requirements for any local eviction moratorium where you're located. Even if the landlord isn't responding, you want to at least communicate what you need to so that you have documentation that you've met your burden. Along with gathering all of your lease documents, you want to save everything, including those original documents, as well as any other written and other correspondence with your landlord. So create a folder in your email account, save any written communication, hard copy communication you received, and make copies and keep them in a folder in just a space where you'll know everything is gathered. You can also print emails and create backups of them. Text messages with the landlord. A lot of tenants text with their landlords about different issues. So you can take screenshots of those text messages and either email them to yourself or print them off. You just want to have copies in case they come in handy later. And then you can also save copies of voicemails. Some voicemail boxes automatically delete older messages, or some folks just delete them to make room. So either save them to your phone or email them to yourself so that you have a copy. And we'll pause to see if anyone has any questions so far. Anna, has anyone jumped in?
What should you do if the landlord wants to exercise their automatic annual minimum increase of 4%?
That's a good question. So it depends on where you're located. Some cities have said that in San Francisco, for example, the landlord can't change the terms of the lease as it was on March 17th. But if the terms of the lease, at that time said that there was an option, or that the landlord could, increase the rent at a set rate, that's not necessarily prohibited. And similarly in Oakland, they have prohibited residential rent increases during the moratorium, but not commercial ones. So it's going to be specific to your location, but in most cases, as long as it's provided in the lease, it is permissible to do that.
So this one wasn't a question, but I think maybe this person's asking kind of what they should do. My lease expires September 2021, and the landlord and the attorney are not talking to us at all. No communication at all in San Francisco.
I'm not sure if this is related to there was a question that came in before the presentation, basically that the landlord and attorney would not speak to the tenant, and that the landlord had cashed a check that the tenant had provided to the landlord. And so I think we probably need a little bit more background facts to be able to answer the question. So I would recommend signing up for a commercial lease consultation just to go over that. I mean, if the landlord and the attorney aren't talking to you, and your lease ends next year, it's going to depend on the location that you're in terms of how long you can defer rent under the relevant moratorium, and different things. If you haven't been paying rent and are able to pay some now, sometimes that's a way to get your landlord to start talking again. We'll talk more about that in the negotiation component of the presentation, but I would suggest signing up for a lease consult for that type of specific question, just to make sure that it's whoever's answering it has all the facts to give you a straight answer.
Thanks, Jake. There's no more questions, but there are businesses from San Francisco and San Jose on the line, and I know some folks registered from Oakland as well.
Okay, great. So we'll cover all three of those, and that's actually the next segment. If you think of questions, just keep posting them in the chat box, and we'll address them at the next question break. So starting with Oakland, Oakland has a commercial eviction moratorium in place through the end of March 2021. And so Oakland's eviction moratorium is tied to the state order by Governor Newsom. And in that order, he authorized cities and municipalities in California to extend commercial eviction protections through the end of March 2021. Unfortunately for folks in Oakland, Oakland went to the maximum time period to have those protections. So if you're in Oakland and meet the requirements, you can not pay rent through the end of March. In terms of qualified businesses, you need to have a commercial or other small business that has 100 or fewer employees, and all nonprofit organizations that are registered as such are covered. So these qualified businesses cannot be evicted for non-payment of rent due to a substantial decrease in income caused by COVID. So if you're wondering what substantial decrease means, the city has not defined it, and so I think it is open to interpretation. I think most of you know your business, you know how you were doing at this time last year and in previous months, and if substantial decrease basically means that you're struggling to pay your rent, struggling to pay your bills based on the decrease in business. Keep in mind that eviction based on other reasons, and that could be noise, nuisance, different things are not covered by this. So it's really specific to non-payment of rent due to COVID. And what this does is it provides a defense to any attempt by your landlord to try to evict you. So if you can't pay rent because of COVID, landlord cannot try to evict you if that's the reason. This covers all rent missed from the start of the shutdown at the end of March. So usually April rent is the first month that was affected for tenants and would go through the end of March. So it's really a full year of rent there. But keep in mind that any rent that's missed during this period is going to come due on April 1st. So, to the extent you can try to work on an agreement with your landlord on the back rent and future rent, it's just going to help ease your burden moving forward. And keep in mind that this could be extended past March 31st, and you could reach an agreement with your landlord that is even farther out into the future than the Oakland one, but you're at least protected through the time period provided in the Oakland moratorium. So just keep an eye on that. There's obviously a long time now between now and the end of March, but just keep an eye out for any possible extensions. San Francisco. So San Francisco is a bit different than Oakland. It is similarly authorized to extend its protections through the end of March. Previously, San Francisco was extending its moratorium on a monthly basis, which was getting to be frustrating because tenants would get to the end of the month, the city hadn't decided anything, and then with a few days to spare, they would extend it. So fortunately, when Governor Newsom signed the executive order at the end of September, San Francisco did extend its moratorium by 2 months. So through the end of this month, I'm hoping that if and when they do extend it the next time toward the end of this month, it will be again for 2 months so that folks are not having to stress out at the end of every month. Hopefully it's just at least every 2 months. This covers rent missed from March 17th when the shutdowns began through November 30th at this time. And it's for qualified businesses that are financially impacted by the COVID-19 crisis. So similar to Oakland, open to interpretation in terms of what financially impacted means, but you, the business owner, I'm sure, know whether you're financially impacted. You have to be a registered business in the city of San Francisco, and your gross receipts for 2019 have to be at or below 25 million. This applies to commercial tenants, subtenants, month-to-month tenants, and holdover tenants. So we talked a little bit earlier about subleases. So if you're a commercial tenant, that means that you have a direct master lease with your landlord. If you're a subtenant, you've subleased from a previous tenant. Month to month, sometimes when you have an initial lease and you don't renew it, it just becomes a month-to-month lease after that point. And that means that you or the landlord can terminate it on 30 days notice unless it states differently. And there's no option to extend the lease. If you're a holdover tenant, that means that your lease expired and there's no new lease, there's no month-to-month agreement that goes into effect after the lease expires. You can still not be evicted if you're a holdover tenant. And as we talked about earlier with the common area maintenance and the additional rent fees in your lease, in San Francisco, rent includes all of those other fees and expenses. So the monthly rent, the additional rent, security deposits, late fees, and interest. So here, if the landlord is able to draw on your security deposit, apply that toward your missed rent, the landlord can't require you to pay back the security deposit while San Francisco's protections are in effect, and that goes for late fees and interest. To claim protection under San Francisco's moratorium, you're going to want to provide written communication to your landlord. Some landlords have asked for tenants to substantiate their financial impact. They might ask for bank statements. They might ask for a note from your accountant. None of these are required. It just requires a written communication. So this could be a hard copy letter sent in the mail. It could be an email. It could be a text message. You just have to say that your business is impacted by COVID-19 and that as a result, you are unable to pay rent. If you have not been sending a monthly communication to your landlord, you need to do it as soon as possible. So you would, for example, at the end of November, if the protection is extended, you would say, especially if you've talked to your landlord about this, you just want to memorialize it and say, as we've discussed since the crisis began, and since beginning of April, I have not been able to pay rent because my business has been negatively impacted financially by the shutdown and the pandemic. My business continues to be negatively impacted and I cannot pay rent for December. So it's just good to sort of document that if you haven't so far, so that you're covered down the road. If you provide this written communication to your landlord, the landlord has to give you 30 days to try to pay back the rent. And if you continue to be economically impacted or financially impacted after that 30-day period, you get another 30 days until the protection ends. So it's important to continue to discuss payment terms with your landlord monthly. Give them an update. If you're starting to do better, but you're not quite at full steam in terms of the revenue and foot traffic in your business, let the landlord know and maybe start to pay, what you can. All of that is going to help, and any payment is likely going to improve the relationship and dialogue with the landlord. And just keep in mind that, again, if you haven't done this yet, make sure you do it for the next month if the protection is extended, and continue to do it for every month thereafter, and if you've been communicating monthly so far. This just means under San Francisco's protections that you are not required to pay any rent during the moratorium. The rent is not forgiven, so it doesn't mean that it goes away, but you are able to keep operating your business. The landlord can't evict you during that time. And obviously tenants are encouraged to pay what they can if they can. And just like Oakland, the landlord can agree to additional protections, extensions in his or her discretion. Some landlords have been very flexible and have offered reductions of rent during the periods of the shutdown or forgiven it. And we'll talk about some of those options during the negotiation section. So as I said, rent relief is what a lot of folks ask about, and this is something that you can ask from your landlord, but it is not included in the moratorium. So anything that has not been paid is technically owed unless the landlord agrees otherwise. And I mentioned this in answering one of the questions after the first section, but San Francisco's moratorium does prohibit the landlord from modifying an existing lease that was in effect on March 17th. So if the landlord's trying to add new requirements, or say you have to pay this additional fee or different things that aren't in the lease, the landlord's not able to do that. So what San Francisco's protection provides is that your landlord can't evict you without providing you with written notice and giving you the opportunity to pay back the missed rent. So they send a written notice, say you haven't paid rent, give you 30 days to do so. If you're still economically impacted after the 30 days or on the 30th day, then the landlord cannot evict you. And as long as you are working with the landlord can't try to evict you for missing payments. So that's why it's really important to at least communicate with the landlord, try to work with the landlord even if he or she's not working with you, and just keep up your end for your protection down the road. And keep in mind, just like with Oakland, that if you haven't paid the outstanding rent either by the time the moratorium ends, which could be on December 1st, very unlikely if it's not extended, or whenever the day after the final extension ends, then that rent would be due, but that's of course subject to any agreements that you enter into with your landlord that could give you more time. So San Francisco is the first large city in the state of California that has lowered itself to its most, or least restrictive reopening phase. So there's a lot more indoor capacity at gyms, at restaurants, different things. So reopening is picking up pretty steadily as long as case counts stay low. I know we did sort of pull back on the reopening schedule to slow it down a bit, but nothing's been rolled back at this point. And keep in mind that there could be more opportunities for relief. The Small Business Administration has opened more economic injury disaster loans. There are also local resources that may receive more funding, and we'll give you the link to that page later in the presentation. And moving on to San Jose. So San Jose's moratorium similarly goes through November 30th, just like San Francisco's. It could be extended through the end of March, like Oakland's is, and it protects commercial tenants from eviction for non-payment of rent at least through the end of this month. San Jose is unique from the other two Bay Area cities in that it has a staggered repayment structure built into its moratorium. And so under San Jose's protection, you have 6 months after the moratorium ends. So say it does end on November 30th, on December 1st, a 6-month time clock starts and you have 6 months to repay half of what you were not able to pay during the moratorium. Once that 6 months is up, another 6-month clock starts, and then you have 6 months to pay the other half of what is owed. Again, you could come up with a different arrangement with your landlord, but you at least have this base level of protection in San Jose. San Jose is also unique from the other cities in that the landlord cannot charge you any late fees if you repay your rent on time. So if the lease provides for late fees, which are usually pretty hefty, they can be 5 to 10% for missing rent. If you repay the rent on time, either pursuant to the 6-month, 12-month schedule provided by San Jose's moratorium or per an agreement between you and the landlord that's different, those late fees are to be forgiven. So the landlord won't be able to charge you, and that's another way to reduce what you owe. San Jose is also very clear in saying that the landlord can't ask you to waive your rights under the moratorium. So the landlord can't present you with a document that says that you give up your right to, repay the rent in 50% increments over a 12-month period, that sort of thing. So any kind of just shady things like that, just keep that in mind. The landlord cannot ask you to do that. Before the landlord tries to evict you, the landlord has to provide you with quite a bit of documentation, has to give you a written notice stating the reason for the eviction, which if it is because of non-payment of rent during COVID, that is a clear protection for you. If it's for another reason, like we talked about with Oakland, it's not going to be covered. So it's got to be non-payment of rent due to COVID. San Jose also requires that the landlord provides you with a notice of tenants' rights, and this is a multiple page document that is on the San Jose City website. So keep in mind that if the landlord tries to do this and says that it's because of non-payment of rent, that's a strike. If the landlord doesn't include the notice of tenants' rights, also hasn't met his or her burden. And then the landlord also has to provide specific rental assistance programs. So San Jose has a pretty steep requirement for landlords. So if they fail to check any of these boxes, it's not going to be a proper notice. And these are all designed to give you more options to try to pay back the rent versus the landlord being able to go right to eviction. It's also important to note that the landlord has to comply with the moratorium. So talked about earlier, the landlord can't try to get you to waive your rights. And the punishment for that is going to be pretty significant. So the landlord could face fines or penalties, damages from you due to any costs or things related to trying to defeat the improper eviction, or hit the landlord trying to get you to waive your rights. And especially if the landlord is trying to retaliate against you for exercising your rights or trying to deny those rights or protection. So anything like that, it's really important to document and make a note of it because it's not allowed in San Jose.
We do have some questions. If you have already signed a commercial lease and we go into another shutdown, is it possible to have a prorated lease during the shutdown? Can the tenant negotiate rent based on cost of sales?
So we will talk about that actually, and there's actually a specific section just so we're not kind of diving into early. The answer ahead of time is it is possible, but it's going to be contingent on what your landlord agrees to. But again, we'll cover it in more detail. In San Francisco, the landlord can charge late fees and interest. So if it's provided for under the lease, the landlord can charge it. It just means that you don't have to pay it during the moratorium. And on a triple net lease, I think is what the triple N means. I think that last question, I'm not exactly sure what you mean, whether it can be negotiated when it's time to renew. So if you could clarify that one, that may be a good question to sign up for a lease consultation for, but if you can add some clarity to that, I can try to answer it after we get through this next session. And any other questions, Anna?
There was a question in the chat box that said, are any of the San Jose protections, will they apply in San Francisco?
No, these are all specific to the city that you're in. So if you're not in San Jose, it's going to be different. You want to go with the protections for San Francisco. And as we said, we'll be providing the slides, and we also have a leave behind document that sort of summarizes these information.
There's one more that came
pieces.
in.
Yeah,
can Oakland? Oh, sorry. Go ahead, Jake.
Yeah. So the question is, can an Oakland landlord charge late fees or interest on unpaid rent? And I believe that is correct. So as long as the lease provides for it, the landlord is allowed to do so, unless it's a residential lease. That is not allowed, but it does not apply to commercial leases at this time. All right, so the reason that we're all here negotiating with your landlord. First thing I always tell tenants when I'm talking to them, I know it can feel kind of hopeless sometimes given the situation and how long the pandemic has gone on along with the shutdowns. But just keep in mind that as an existing tenant in a space that has, a business with goodwill, and that means a customer base, you have name recognition, reputation in the neighborhood, all those things. It's much better for the landlord to keep you than it is for the landlord to try to kick you out and bring in someone new, which would, possibly create all kinds of new headaches for the landlord. So keep that in the back of your mind when you're coming into these negotiations. In beginning this process, you need to get your landlord to come to the table and negotiate. So how do you do that? The thing that I usually tell tenants is that you want to put yourself in the shoes of the landlord, which I know none of us probably want to do at this time, but it's important to do that anytime you're negotiating with someone so that you have their perspective in mind when you're coming up with a proposal. And what does your landlord ultimately want? Your landlord wants to be paid the rent under the terms of the lease. So how can you best achieve that? Really, you want to come up with a realistic offer that is going to at least partially check that box for the landlord. So some payment of rent at some point, even if it's not now. And also it needs to be affordable for you. So, keep in mind that the landlord, and you can use that, you can remind the landlord of this when you're talking, if you have been in your space for a while and the landlord's going to go out and try to find a new tenant, especially if any work that would maybe require a permit needs to be done on the space, maybe it's a little bit dated, maybe the bathroom isn't ADA compliant, any kind of work at that level is going to trigger all kinds of new requirements. The city loves to force landlords to update their spaces during these changeover periods. It's going to lead to a lot of downtime where the landlord doesn't have anyone in the space. Plus, there is a glut of commercial space in the city right now, so the landlord's probably going to have to be more competitive with the leasing rates, and the tenant, any new tenant, is going to have the upper hand in terms of negotiating. So it is to your landlord's advantage to keep you there, and also, could give you an upper hand in negotiating the different concessions and things that you need to continue operating in the space. Also keep in mind, again, as hard as it might seem, empathy can go a long way. I think a lot of tenants assume that, landlords are just making bank off of leasing the space and, they don't really need the money, which may be the case if it's, a building that was inherited or one that's been paid off for a long time. The landlord might not need the money as badly. But if the landlord has a mortgage on the space and is struggling to pay it because he's not able to collect rent, which is obviously not your fault either, but the landlord could have similar stresses. So it's good to kind of keep that in mind and know that the landlord's not always coming from a bad spot, but is sort of in a similar position to you. And just keep in mind, and I think this number has gone up, but there have been at least 5,000 small businesses that have closed since the shutdowns began. And so again, there's going to be a glut. There already is a glut of commercial space, and it's going to be a lot harder for the tenant, or excuse me, for the landlord to fill the space if you move out. So along with keeping the landlord's perspective in mind, you also want to make a realistic assessment of what you can do in terms of repaying back rent and paying monthly rent moving forward. As a lot of new businesses open back up, hopefully you're seeing an increase in foot traffic, but it is taking time to kind of get that daily walk-in, online ordering, all that stuff kind of back up as people come out and start spending time in their neighborhoods. So you don't want to, say, well, starting December 1st, I can pay full monthly rent and I'm going to be able to pay $5,000 toward the chunk of back rent that I was not able to pay before December. That is going to just set you up for failure. You're not going to be able to make or meet the terms of the agreement that you made with the landlord. And it's going to cause repeated renegotiations, which are likely to get worse as they go on. So, if you need a 50% reduction in rent moving forward, tell the landlord that. If you, want a forgiveness of all rent that was missed while your business was closed, ask for it. You don't know what the landlord's willing to do unless you ask, but just make sure that it's realistic and it's something that you'll actually be able to pay. And like I was just saying, don't be afraid to ask for the moon. So you don't know what you don't know until you ask. So this could be abatement for the duration of the pandemic, which would mean that the rent is reduced as long as the pandemic is still classified as such. So say 6 months from now, we've got a vaccine or somehow herd immunity is present and the cases continue to decline, it's no longer a pandemic, then your rent would go back to full price at that time. But until then, it's reduced by X amount or percentage. You could ask for additional time to repay the back rent, 12 months, 24 months, whatever the landlord's willing to commit to. Or you could say, you have 3 years left on your lease and, divide what you owe by those 36 months and you'll pay that amount to extinguish the back rent by the time the lease ends. And again, you could also negotiate extensions to these reductions or other protections beyond when the moratorium ends in your city. So if San Francisco's ends in November, the landlord could grant you additional concessions or protections beyond then. It's all subject to what your landlord's willing to do. Some tenants have also been able to convert back rent into a loan. So they've been able to borrow that amount against the business and just make it a monthly payment that they could make. And that makes it a little more flexible because you're paying off the landlord in one lump sum and you can get a longer term to pay back the money. And there are opportunities to refinance and different things that could extend the repayment period down the road. Some tenants can also just ask that the deposit be credited toward the back rent and then give you an extension to repay it or possibly waive that requirement. Maybe you just have to pay back the deposit by the end of the lease, or the landlord just agrees to charge you any maintenance or cost to fix damage once the lease ends. Whatever you think is going to be most useful for you. And it's possible that a landlord would forgive or at least reduce rent that's owed if you make a promise to pay full rent moving forward. Some money is money for the landlord, so getting something when the landlord hasn't been receiving any rent could be a motivator, especially in situations where it's a family or the landlord owns the building and doesn't have any debt on the building. They might be a little more flexible. Especially if you've been a good tenant in the past and they've earned a lot of money from your tenancy. If your lease term's about to end, even if it's into middle to end of next year, leverage a lease extension because, like I mentioned, it's going to be hard for your landlord to get someone in that space, especially if it's a new business. And so leverage that and say, if you give me 50% off of my back rent, I will, sign my lease extension. Or if you forgive my rent, I'll extend it for the longest option, those kinds of things. And it never hurts to ask your landlord if he or she is receiving any mortgage assistance. A lot of the big banks, if any of you have been able to utilize this for your home mortgages, they are offering mortgage assistance for entities that are struggling. So just like you can go to the landlord and say, I'm negatively impacted by COVID financially, the landlord can go to the bank that holds the mortgage and say, my tenant's unable to pay rent because of the crisis, therefore I'm unable to pay my mortgage, and they can push out their payments. If the mortgage is through a bank that doesn't offer that, then the landlord's out of luck. But we've had some situations where the landlords have been receiving assistance, but then trying to get the tenant to pay full rent, and obviously that's not allowed, and it's not required of the tenant under the moratorium. So it's good to just get all the facts and kind of know where everyone is at. Like we talked about with making a realistic ask, you don't want to overcommit. Again, that's just going to lead to more renegotiating. What some folks have talked about, and this was a question that came in before the presentation, is can you propose that repayment be tied to your monthly revenue or a set amount? What I've talked to other tenants about is proposing that they pay 50% of the monthly rent, for the next 6 months, and a percentage of their revenue, 3%, 5%, 10%, is going to go toward repaying the back rent. The percentage versus a set amount is useful because the landlord is going to get something. Even if you make $1, the landlord's going to get 5 or 10% of that. And if you get really busy and business picks up, the landlord could make more from that percentage than a set amount, a lower set amount. So there's a way to sort of sell it to the landlord where minimum the landlord's going to get something, and in a really ideal scenario, then the landlord is going to bring in more money than he or she might have with a lower set amount of monthly repayment. And you could also ask to convert your base rent moving forward to percentage rent. So 25% of your revenue is what your base rent is for the next year or something. These are all things you can ask for. It's going to be up to the landlord whether or not he or she wants to do that, but you don't know if you don't ask. At the same time, if the landlord is just being ridiculous and sending threatening texts or calls, or sending legal demands and different things, just meet the requirements of the moratorium in your city. Send the written communication, document it, and be done with it. There will come a time where the landlord's going to have to talk to you because they're either going to pursue eviction after the protections end, or your lease is going to be up, or there's going to be some event where the landlord has to talk to you. So do what you have to do to protect yourself, but you don't need to drive yourself nuts with all the other stressful stuff going on, trying to please a landlord that is not capable of doing so. So just keep that in mind and protect yourself to the extent you can. In terms of next phases, reopening continues. California, thankfully, has dealt really well with the crisis, even while we're having all these spikes elsewhere. So hopefully we keep trending in a positive direction. And what's sort of remaining to be seen is how these defenses that we talked about a little bit in the beginning, in terms of what your lease does to protect you, how these defenses hold up in court in an actual eviction proceeding. Because of these moratoria in Oakland, San Jose, and San Francisco, there haven't really been eviction proceedings on the non-payment of rent element. There may have been others for nuisance and things, but these defenses for non-payment have not really been considered in the area so far. In terms of additional assistance, everyone is familiar with the PPP loans and stimulus that came out earlier this year. Obviously, the election isn't decided yet, and there has been no movement on the stimulus that was passed and then sort of toned down and repassed by the House last month. We'll see what happens from there and whether anything at the state level comes out. And as we talked about before, Governor Newsom could extend the executive order allowing cities to extend protections beyond the end of March. One issue that courts have ruled on in a couple different locations is the application of business interruption insurance to the pandemic. Many of you are required under your lease to have business interruption insurance. And the courts so far have said that the pandemic is not one of the covered occurrences that would be qualified under the insurance policy. But it's important to look at each policy, specifically your policy, to see what is listed as a qualified business interruption. So government mandated closure, things like that, even if it doesn't mention pandemic, could be interpreted or argued at least to be something that would be qualified for coverage under your policy. And again, another reason to sign up for a commercial lease consult if you can. Keep looking into community resources. In the past, these specific resources by location in terms of your neighborhood or city. There's all kinds of different qualifications. Some of them are privately funded. Sometimes, if there's more federal stimulus that comes, some of the city programs in San Francisco, for example, could reopen. So just continue to look and update because even if there's nothing right now, there could be more resources moving forward or as we go into the next fiscal year at the beginning of January. In terms of additional assistance, the Lawyers Committee's website, which is lccrsf.org, has different resources listed. You can sign up for one of the 1-hour consultations to talk to a lawyer for an hour, complimentary charge. And you can sign up as an Oakland-based business at this link here. And if you're outside of Oakland, at the second link there. And again, we'll be providing the slides and a leave behind document that will summarize all of this for you. If you're looking for city-specific resources, Oakland, San Francisco, and San Jose all have their own pages with resources for commercial tenants and businesses. So keep an eye on those, check them regularly. The OEWD website for San Francisco in particular has a whole financial resources page of what's available. And again, always subject to change, but these links will also be included in the presentation. And I'll open it up for questions now. We did get some questions that came in before the presentation, and I can buzz through those while folks think about other questions that they have. And some of these I think we've already covered. So what do I have to do if I close my business permanently or file for bankruptcy? In terms of what happens, it's going to depend on a couple things. The first is whether your business is formed as an LLC or other independent entity that's not in your name. In that case, usually the business winds up, its assets are pooled, and at least in bankruptcy, each of the creditors make a claim and the court divides up the value of the assets and each creditor basically gets a chunk. So it extinguishes the business and you can move on. The key for a lease for you is going to be whether you, the owner or owners, personally guaranteed the lease. If the business signed the lease and you did not personally sign it in your personal capacity, then the landlord would be one of those creditors that is going to apply to the bankruptcy court for a portion of the assets. So that's a protection that is ideal in your situation. If you're in that situation, if your lease is personally guaranteed, there are other considerations, especially if you own a home, if you have other personal assets, those are things the landlord may be able to come after. And to the extent we can avoid that, you want to try. So it can definitely be in your best interest to continue to negotiate with your landlord if the lease is personally guaranteed and try to reach some sort of agreement. Again, this is going to be probably a more fact-specific question for a lease consult, but keep at least sending the written communications you need to your landlord. And it could just be if the landlord's not going to talk to you, then do what you need to do to protect yourself and wait for the landlord to reach out. And again, if the landlord, if your lease does have an annual minimum rent increase in the lease as it existed at the beginning of the shutdowns, that is allowed. But you would similarly not have to pay the rent at the increased rate as long as the moratorium's in effect and you are economically impacted by the COVID crisis. If the landlord refuses to accept your attempt to exercise an option to extend your lease, that is really going to depend on the language of the lease itself. Usually both parties have to agree to that. So the landlord, it's an option, it's not a requirement. So you could say, I want to do this, and the landlord could actually say, no, like this isn't working out, or I'm selling the building or whatever, and decline. So if it requires mutual assent, which means that the landlord and you have to agree, and the landlord says no, the landlord can do that. If it's unilateral and you have the power to extend the lease and it's not subject to the landlord's consent, that would be a different story. So I would sign up for a consultation just to make sure that the language is reviewed by a lawyer. And this last question, what do I do if my landlord has insisted that I pay rent during the moratorium period? So we've seen this with a lot of tenants. We've also seen tenants that have willingly paid rent during this time. In some cases, they have taken a significant hit in their savings to try to keep paying rent. And just keep in mind that it's not required. If you're economically impacted, if your business's revenue is still down, you are not required to pay any rent, let alone full rent. And even if you've been paying rent, you can stop as long as the moratorium's in effect. So regardless of what the landlord says, if you're in San Jose, San Francisco, Oakland, or another local city that has a lease or an eviction moratorium, review that, and all you have to do is provide that to the landlord and say, even though I've been paying rent and trying to work with you, I don't have to pay rent through X date under the moratorium. I'm still economically impacted. I meet the requirements. I will not be paying rent. The ideal part of you having paid rent during this time is that your total amount owed is much smaller. And again, tenants are encouraged to pay rent, but they do not have to. So you can exercise your rights under the moratorium in your location, and the landlord can't do anything about it. And you're going to look like the good guy, because even when you didn't really have the money, you were paying at least some rent. And the landlord also sort of duped you into paying, or pressured you into paying, when you didn't have to pay anything at all. So the landlord's the one that's going to look bad, not you. All right. Any other questions that have come up for folks? We have about 5 minutes left if folks have things they want to raise in the chat box.
There is one in the
otherwise, oh, go ahead.
And this is for a business owner in San Francisco. I'm in a situation where I'm negotiating my lease in a building that has not been retrofitted and needs a lot of work inside and out. I've been in this space for more than 6 years. How will this affect the negotiations?
That's a good question. I mean, it can be helpful in that kind of situation to find a comparable space, or, if I'm not sure what exactly the space needs to be built out as, or whether, there's wiring or plumbing that needs to be updated, needs an ADA bathroom put in, that kind of thing. But if you can find a space that is built out the way that you need it, and you can use that as a comp and say, I could not renew my lease, move into this other space that's already built out for me, and be paying less rent. So, anything like that you can find is going to be useful in the negotiations. I think the one thing with retrofitting, the landlord could try to charge you more money because they'll say, well, I'm making all these improvements to the property. If there are things that you're requesting for your business, that's sort of a different story. If it's something that is required by the city, or the landlord wants to do it just to update the space, whatever it is, that's not something that's really your responsibility. The landlord is the owner of the building, and if the landlord is being required to make those changes, or is choosing to make those changes that are not required by you, the landlord will sometimes try to pass those costs off onto the tenant. And unless you're specifically asking that they be done, not really your problem. And if these are going to create interruptions in your ability to run the business, you're going to have to reduce your capacity, or you're going to have to only do takeout, or I don't know your business, but there are different things you can ask for in that process, reduction of future rent or different things. And the nice thing about your lease being up for renewal is that that's a pretty heavy negotiating tactic because you can walk and the landlord can't do anything. So that might be a good thing to sign up for a lease consult to discuss.
There's one more question. Could you show reduced backlog and revenue forecasts in coming months as negative impact versus actual reduced revenue or profit?
Yeah, I mean, it's going to be more current than future, right? Because you obviously can project that your revenue is going to be down, but each month when you write the landlord and say I continue to be economically impacted, that's going to really be based on the previous month or months. So I think you could maybe include that in the written communication, but you would say we continue to be economically impacted. We project, based on the reopening and the reductions in capacity, we will continue to be, but you still need to make that communication each month, and it's really going to be based on the previous month, preceding months. We got a question about consultants fees. So if you sign up for a lease consultation, it is limited to an hour. It's a limited scope consultation, which means that after the hour is done, there's nothing more. You can sign up for another 1 hour session, but it doesn't go beyond that. We can't represent you in court. We can't, draft legal documents really for you. I have helped some tenants just draft a demand letter to get their deposit back after they've terminated their lease, for example. But there would be no charge for the 1 hour consultation. It is just limited to that time. So any way that you can avoid having to pay legal fees, that's why we're offering these 1 hour consultations. And it's just a volunteer like me or someone at the lawyers committee who's meeting with you. We can do a video chat on Zoom or Microsoft Teams, or we can just do it on a call. I see one more question came in. And so the question is, we've been in our space for 22 years. At first, the landlord offered to reduce rent by 40% for the first months of the pandemic, then a 25% reduction for a few more months. Now they only want to reduce it by 10%, and that is not going to work for the business. Can you try to negotiate for a further reduction? You can try to negotiate for anything that you want. It's really going to be conditioned on whether the landlord is willing to work with you and accept it. So, if the landlord's saying, I can only do 10%, and you say, sorry, that's not going to work for me, the landlord's probably going to have to think of something else. So, especially if you're near, the end of your lease term or something, try to use any negotiation tactic you have, at the very least, keeping you in the space so that your business can continue to recover and eventually get back to where it was before the pandemic. The landlord in the long run is going to make more money from you staying in the space, even at a further reduced rent, than they would if they say, no, 10%, take it or leave it, and you walk. They're getting no rent versus less rent. And we have another question. I have a new lease that I have not signed yet. Would you be able to review it? That is something you can ask the lawyers committee to do. So when you sign up for a lease consultation, you would submit an application, and if you're accepted, you meet the requirements, then the lawyers committee would provide the unsigned lease to the assigned volunteer to review it and then go through any questions. It's going to be helpful if you have specific questions about the lease so that the lawyer kind of knows what to look for. But if you just want a review for anything concerning or that looks a little sketchy, you can ask the landlord or the lawyer, a volunteer, to do that. And again, you would have a complimentary 1 hour session to talk with the lawyer about the lease.
There's one more question in the chat, Jake. The landlord is negotiating through a proxy, a realtor. How do I manage that?
Can you say that again, Anna? Because I'm seeing a different question on the.
Oh, yes. So this one's from the chat that came in, the chat box. The landlord is negotiating through a proxy, a realtor. How do I manage that?
Landlords often negotiate through like a property manager or something like that. If the property manager is not being reasonable, you can try to reach out to the landlord directly, because sometimes the landlords are especially larger landlords, are so far above it that they, they don't know the day-to-day. And if they are sort of looped in on how the property manager is being, especially if the property manager is being unreasonable, that conduct is going to be imputed to the landlord if it gets to an eviction proceeding or something. And so that's just going to make the landlord look bad, which the landlord probably wouldn't want. So again, it's going to depend on, you know, how the property manager or the go-between is acting, but just keep that in mind. And if you want to, you know, give more information and sign up for a lease consult, I would recommend that. So we have a question about whether the recording will be made available. It will. We'll also make the slides available and then provide a leave behind document. And we did have a note. Again, you know, if your business is doing well, obviously some businesses have done better than others during the pandemic. You know, think about your relationship with your landlord. If you've had a good relationship with the landlord before this all started, you've been generally friendly, you know, keep that in mind. And those are usually the positive interactions that we hear about in doing these consults, that the landlord is being very flexible and, you know, understanding and being willing to work with you. You know, you don't want to take advantage of the landlord in the same way that you don't want the landlord to take advantage of you. And, you know, as we talked about empathy earlier, the landlord likely has, even if the landlord owns the building outright, has insurance, property taxes, and things that he or she has to pay. So there's no situation where the landlord is just, you know, sitting there counting money, you know, waiting for you to give them more. They have their own bills and things that they have to pay. So just try to be fair as you would want the landlord to be fair to you. And with that, just to kind of keep us, we're a few minutes over, but again, we encourage you to sign up for a commercial lease consult. You can go to lccrsf.org to sign up for that. And feel free to reach out to the Lawyers Committee with questions. We can always answer those via email. We will post the recording, and you all have a good day. We did have a question about other legal services. You can see what other services are available on the Lawyers Committee website. All right. Anything else, Anna?
That was it. Thank you, Jake. Thanks,
okay,
everyone.
Thanks, everyone, for showing up.
We'll send the webinar link and slides this week. Bye.
Bye.